using a laptop mic and a Bluetooth speaker.
Yeah. Hey, Joseph.
Okay,
can you,
any better or not?
Better, a lot better.
Okay, no, because it's a different sound card. All right, yeah.
Okay, good. That's good. Okay. All right, great.
So Husam, you're gonna ask all the difficult questions.
Hold on. Why is that? Why is that feedback?
Don't know.
Testing. See, I can hear my voice coming back.
Yeah, same here.
Yeah, how about me?
Okay, I tell you what. Why don't Husam, you speak, and then we Joseph and I mute.
Okay, is it me?
Yeah, can hear you. Still got the echo.
Let's do troubleshooting. You see, even when you guys talking and feedback, so it doesn't work. But can you guys hear my feedback?
Yeah, I can hear you going.
We need to resolve this.
Joseph, maybe because.
Okay, let's adjust our mic volume. Pizza. We are all on. Except the problem with the sound and hear our echo. It's very weird. We can hear our echoes. When I'm talking,
Can we stop the background echo?
Okay. I'll call you if you are testing it out at the moment. That was Hafiza just now.
Who's continue?
How do I check the setting?
That's always the bad thing about seeing the first all the technical problems.
Look. Oh no, I'm here already with Who is PAM training?
Hello, you went back to the office.
No, I didn't.
Okay.
That's my house. Hey, I really don't know how to carry up the echo. How do you guys manage to do it?
I think it's the system at PAM.
Yeah, the organizer. Can you switch on your mic and
Okay, I think let's run through. So basically, Husam you will be introducing, and then Joseph you will take control of the slides. All right. So after that, when you hand the baton over to me, then I will share my screen. Okay. That should be the way. All right. Okay. Sam, you were not in the briefing the other day. they were saying our session is 1.5 hours.
Yeah, actually,
You do your normal introduction.
Participants are listening to us.
Is it?
I think so. Somebody please kill the video.
Let me go downstairs and check. They can solve it. Okay. Bila bercakap, dengar. Ada echo tu. Headphone. Jika headphone tak ada mic. So macam mana? Ada headphone. Tapi bukan saya. Memang lampu juga sama. Loo, Husam, can you speak?
Yeah, Husam here.
Loo, are you okay? Can you test?
Sorry, I just walked out. What is it? Okay, testing. Can you hear me? How do you do it, Joseph?
No, I haven't solved the problem.
I tried putting on a mic, or rather a headphone, and it doesn't work.
Okay, I'm trying now. Dengan phone juga ada echo.
Hello.
Testing 1, 2, 3.
Kita Husam, can you speak?
Husam, can you speak?
Hello. Test 1, 2.
Okay.
Is it better now?
No, I'm still here.
Okay,
I
because
can see
I still have an echo. Loo, can you try?
1, 2, 3, 4. 1, 2, 3, 4.
Again?
1, 2, 3, 4. I can hear a lot of people on my side.
Dia pun
masih ada true echo juga.
No, you nak set
Setting ya.
Very good morning. Architect Abu Zarim, PAM Deputy President and also the Chairman of CPD Committee, PAM Council members, PAM members,
Hello,
PAM CPD committee members, secretariat staff, and also Garis Pixel, who is providing the technical support for this CPD online program. Welcome to this session of PAM CPD Unlimited. 2 years ago, in November 2019, we had our first CPD Unlimited for the first time. I was invited by architect Wan Sofia, the coordinator for the CPD Unlimited 2019 program, to present a paper. Regret that I have to decline the invitation because it clashes with my another program, the 9th Annual Development Conference in Singapore, where I was invited to present a paper together with our Minister of Housing and Local Government, YB Zuraida Kamarudin. I was informed by architect Wan Sofia that the session in KL was well attended and there were minor issues on car parking space and room availability when we did the physical session 2 years ago. Time allocated for speakers were too short. Some couldn't finish the session before the following session starts in the same room. So initially, Architect Abu Zarim, the CPD chairman, planned to have physical CPD Unlimited program on 15 December last year. But due to the pandemic, then we have to postpone to 9th of January 2021. But again, the MCO was also extended several times, affecting our schedule. Finally, we have decided to have this session online. So today, this session will be conducted fully online due to COVID-19 pandemic and the SOP that we have to comply with. I hope this virtual session eliminates the problem that we had before. No more car parking problem, no more room availability problem. But please be prepared and tolerate with us. With this virtual session, speakers are everywhere. They are at home, in their office, and some are at PAM Center. So we are running multiple sessions concurrently. It is stretching the internet bandwidth that we have. But we have our technical team on standby. So we are experimenting this virtual CPD Unlimited for the first time. There are many things that we will learn from this session. Speaking on learning, I hope participants will learn new things from this program today. Under this pandemic and economic challenges, it is like racing. Every day we have to learn and get the new knowledge. Otherwise, we'll be left behind. We are happy to have our speakers willing to share their knowledge and new technologies with us today. I am glad that we have Architect Razin Mahmud. He will be sharing his journey, small team with big dream. And we also have Dato Architect Saiful Anwar Aziz. He will be sharing his experience as a sole proprietor exporting services overseas. And of course, our special guest, Dato Sri Engineer Zaini Ujang from Ministry of Environment and Water. He will be talking about eco-shift in built environment. We also have Taufik Nazaruddin Nohayati Ahmad speaking about digital solution and Internet of Things. We also have Associate Professor Dr. Ahmad Tamizi from UMP Holding. He will be speaking on BIM organization transformation. And we have Architect Gary Wong also talking about BIM today. And other than that, we have many more speakers on various topics. On fire safety design, we have Architect Chong Lee Seong, Engineer Hao Jiang Te. On construction contract related subjects, we have Architect Joseph Tan, Architect Loo Chee Keong. We also have David Yet. We'll be talking about mediation and dispute resolution. We also have the topics on conservation by Mariana Isa, Mangjit Kaul, Architect Rida Razak, and Ahmad Najib Arifin, and also on urban design by Associate Professor Dr. Sharifah Salwa. I will not be able to say all to mention all the names, but there are many more speakers. You can check with the program. And later in my session, I will also share the finding from our survey from the government agencies, developers, contractors, and individual project owners on what do they expect from architects in providing architecture services. Recently, we have conducted a survey to get the feedback from developers, contractors, and also government agency on their expectation on architects' services. And on behalf of PAM, I would like to thank each and every one of you for being here virtually today. This is our first ever virtual CPD Unlimited program. Please give us feedback at the end of the session so that we will improve things in the future. I hope that all participants will enjoy this session and have a good interaction with the speakers. Make sure you interact with the speaker. Don't just leave your computer on, but you are not there. So enjoy the session. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Thank you.
Okay, you can try. Tak dengar.
Seems like we don't have any more feedback.
Is this okay now?
But I can't hear
Yeah, I
myself.
think it was that video just now.
Okay, can you hear
Okay,
me?
fantastic.
Can you hear me?
Yeah.
Okay,
Fine,
good.
Joseph, no feedback.
Okay,
Very
thanks.
good.
All right. Boleh. So Husam, you on now?
Yeah. Hello, everybody, and a very good morning. I realize I think all of the participants have been logging in straight and have been listening to us dealing with the technical difficulties. I hope I hope it's resolved now, and I do hope that the organizer will look into this. It's very annoying. And okay, hello again, and good morning, everybody. My name is Husam. I'll be. I don't think I can moderate this because I have two distinguished speakers, very well versed and also very experienced. We have architect Joseph Tan from Tangent Design, and we also have architect C.K. Loo from Arc Partnership, and they'll be talking about COVID-19. So what the PAM form can and cannot do for you. So this is the 46th day of the MCO 2.0 since it started in January 12th, and this is from last year's MCO 18th of March. It has been 346 days. And over the period of the MCO, one of the issues that has been plaguing the construction industry is obviously on contract matters. And for the first few weeks, I think we've seen people from other sectors like the lawyer and the insurance, and they've been talking about what we can do when it comes to contract. And from PAM, we do have that one PAM practice forum, which was last year in December, where we spoke about the COVID-19 again. But that was in a broader manner. So today we have Architect Joseph and Architect Loo to speak about the PAM form and focusing on what it can and cannot do for COVID-19. So this session runs for an hour and a half, and we have basically two speakers, so they'll split between the two of them. We'll start first with Architect Joseph, and I'll let Joseph later introduce again Architect Loo for Architect Loo's presentation. All right, and we have the chat box down there. I think some of you have learned how to use it yourselves. So you can write down your questions if you have. I know like all of you have a lot of questions when it comes to contracts, especially those who are actually running projects at the moment. I'm not sure if you want to raise hand and ask questions, but during the presentation, but probably we can reserve that for the Q&A session, which we are giving about 15 minutes at the end of the session. Okay, so without further ado, I would like to invite Architect Joseph Tan to start his presentation. Joseph, on to you.
Okay, thanks, Husam. Morning, everyone. Hold on, let me share screen. Okay, maybe the slideshow. Can everyone see the? Okay. Whoops. Thanks again, Husam. So, all right. This session, to start off with, this is a subject which is going to take you either 3 days or we can finish it in 15 minutes. Normally, if it was at PAM Center, we finish it in 15 minutes, then we all go for coffee. Anyway, we'll see how it goes. All right. Now, the introduction, this paper came about, it's an old subject, but it came about because I still remember at the onset of the pandemic when the MCO was first introduced. And on some of the PAM related WhatsApp groups, full of questions. What are we supposed to do? Jobs on site, what's going to happen? So there was a lot of feedback, and this paper is as a result of what I think it's not a generalization of the feedback, but it's basically my views on some of the feedback. Okay, so I really said this paper may be too little, too late. Crossing fingers, hoping next week, 4th of March, MCO will be lifted for people like us in KL. But even if it isn't, or even if it is, this pandemic is not going to go away. And some of the problems, I would like to think all of you will have solved all your construction problems by now. But if you haven't, well, hopefully this paper may give you a little bit of direction. All right. Now, this is prepared because it's CPD Unlimited. It's supposedly for architects, but generally, if there are other people, I hope you can also find some use from this paper. Okay. The references are very simple. PAM contract 2006 and 2018. Okay, if you all should know this one anyway. The other thing which we've referred to in an oblique way is the temporary measures for reducing the impact of coronavirus disease 2019 Act 2020. Okay, this is Act 829. It's commonly known as the COVID-19 Act. All right. And the last but not least, the other reference is PAM's own practice note serial 3-2020, which was issued in December 2020, just 2 months ago. The title of the practice note is Contract Administration in Relation to COVID-19 Act 2020. Now, right at the bottom of the PowerPoint slide, you can see that this note. This paper is a guide on current points of deliberation and that all contractual scenarios are unique and will need to be assessed individually for the merits of each case. This is another way of saying, please don't expect this paper to give you answers. And if you want to blame anyone, blame architect Loo, because he's a very good architect. Okay, this is what I call a CBC, cover backside clause. All right. If you can't find the answers, or if you find the answers and they're wrong, don't blame us. All right, move on. Okay, so some clarifications and reminders. COVID-19 is a disease caused by the SARS-CoV-2 virus. As the disease is very infectious, its spread is classed as an epidemic. And because this epidemic has spread over a very wide geographical area, it's started in Asia. From Asia, it's gone through to West Asia, then to Europe, to North America, South America, and now it's also in Africa. So the WHO have classified this rightly as a pandemic. Okay. Please note though that this is not the first and only epidemic suffered in Malaysia. If you look into the past, Malaysian construction industry has also suffered various epidemics. I still remember as a child, there was a cholera and a typhoid epidemic. Okay, Malaysian construction industry in those days has still managed to move on, no problem. All right. Due to its highly infectious nature and the high mortality rates associated with it, from what I see in the papers, over 2.5 million people have lost their lives because of the pandemic since its beginning. Okay, and that's probably a conservative estimate. All right, governments have been forced into action using legislation to implement measures to control its spread. Okay, in Malaysia, there was a already existing piece of legislation called the Prevention and Control of Infectious Diseases Act 1988, Act 342. The government using this act put in place various movement control orders. It started off with the movement control order, which then evolved into the conditional movement control order, and then which then in turn changed to the recovery movement control order. And for people like us in KL, it's changed back down to the movement control order. Now, the movement control orders all came with different standard operating procedures, SOP for short, everyone knows that, okay? Now, the timeline for the introduction of all these various movement control orders up to the end of last year and the SOPs has already been very well covered by other people. If you all need reference, Anthony Lee has done a very good chart timeline which shows all this. Rather than go and try and copy him, I would suggest if you want to refer, if you need reference, try and find his talk on it. Okay. Now, I would argue that the disruptions we see, cannot go to work, or if we go to work, have to work from home, or the construction industry having to work at a reduced efficiency, all these are principally due to the above movement control order and SOPs, okay? So having gone through all that, all the things I've talked about, what has this got to do with the PAM form, okay? So please wait a while and we'll see. Okay, I've already mentioned due to the imposition of the various MCOs and the SOPs, almost all construction sites would have stopped under the MCO unless you were doing, there was a short list of essential work. I think if you're doing work on slopes, etc., where if you don't work, the slope will collapse. Almost all construction sites had to stop work, okay? Or they were delayed when the conditional and the recovery MCOs came into place because of the SOPs. You had to have social distancing, you had to have minimum number of work, maximum number of workers allowed. This is still happening, okay? So what does the PAM form do for me with all these various MCOs and SOPs? Should be obvious, lah. It goes without saying that works will have been delayed, all right? So the great thing about PAM form is that it allows you all to resolve or run through this delay because the contract allows for extension of time. Might sound stupid, but you must remember, not all building contracts necessarily allow for extensions of time, okay? And by having a provision for the extension of time, it allows you to set a new completion date, which if you exercise it correctly, if you don't arbitrarily set a new completion date, it means that EOT will be given, and most importantly, time is not set at large, all right? New completion date, once you set the new completion date, time is not set at large. Contractors, they are given more time to complete the work, and employers do not lose their right to claim for liquidated damages. And most importantly, with this extension of time clause, architects know what to do. Now, it might sound stupid, but I'm telling you a real story. During CMCO, no one went to my work, no one went back to work, okay? My office, one day I had to go back, do a bit of admin. I opened the door, the whole floor was all wet. Water supply pipe burst in the ceiling, all right? Am I going to use PAM form? No lah. I get the plumber in, I get the contractor in to do the repair. If I get them to do it, he gives me a quotation, I say yes. No PAM form. He tells me how long? No, he tells me it takes 2 weeks. After 2 weeks, he hasn't finished it. Technically speaking, time has been set at large. But because it's a small job, because I owe him lots of money for the work he's done, this is a risk I am willing to take. Okay? But for other jobs which involve other people's money, clients' money, which may run into the millions, having a contract with extension of time provisions is important because it allows you to set new completion date. Time is not set at large. All right? Okay, but does the EOT clause under PAM really cover the COVID pandemic? Okay, now contractors can, under the PAM form, they can apply for whatever reason they want to. There's nothing to stop them from submitting an application. All right, but you must remember as an architect, you are only empowered to grant EOT for certain events, the relevant events, which is listed under clause 23.8 of the contract. Okay, if you run through this list of relevant events, and you compare it to what's happening with the pandemic, I actually think there are quite a few relevant events which a contractor can apply for EOT. Okay, if you look at the PAM form, now one of the things I don't like doing is telling contractors what to do. I like even less telling architects what to do. They should tell themselves. But if you look at PAM form, if you look at clause 23.8a, 23.8h, 23.8p, or 23.8w, have a look and let me know. Do you think if a contractor used these relevant events to claim for EOT, do you think you would be obliged to actually grant them the EOT? Okay. Okay, and let us not forget, PAM form is great because it gives you a procedure for claiming and granting EOT. Now, the procedure is quite long, but that is the difference between the PAM 2006 and 2018 and PAM 1998. This procedure, though, isn't there to make life difficult for contractors or for architects. All right. The principal reason why it's there is to make sure that delays are dealt with contemporaneously, okay, in a timely manner, so that it is not left to fester or people forget about it. I used to have nightmares when using PAM 1998. It is Friday evening. It is 5:30. The job I have on site, completion date is on Monday. Never mind. I know the works are not going to be complete. I'm packing up to go home, enjoy my weekend. So at 5:30, I hear the door knock. Ding dong! Somebody rings the doorbell. It's the contractor, and he gives me a whole stack of documents and tells me, Mr. Architect, this is my claim for EOT for the relevant event that happened 12 months ago. Please process it now, and you don't you dare give me a CNC on Monday because I already submitted. Now, under PAM 1990, I can still say rubbish. I'll still issue it if you are not completed, but it's a nightmare. Now, with PAM 2006 and 2018, there's a procedure which should help reduce this problem. Okay, if a contractor thinks he's going to be delayed, he's going to give notice. And he's going to give you a rough estimate of how long he thinks he's going to be delayed. Now, then at the end of the course of delay, within 28 days, he's going to give you full particulars. And within six weeks of receipt of the full of the details, you can either say no, there's no EOT, reject the application, or you can actually during that period say not enough info, give me some more, or you can issue the EOT. There's a process. So if the contractor thinks he's being delayed, give notice. Don't go and give me a notice 6 months from when you thought you were going to be delayed. Okay. The contractor's job is to run the job. He is to manage it, monitor it against the program. So it's also the architect's job. So all these things you have to continuously monitor. Please don't give claims for extensions of time in an untimely manner. All right. Now, this may be a good time now to make a small diversion. diversion. Okay, when in March, April, when the MCO came about, you read newspaper, you read PAM chat groups, you read everywhere, everyone's going force majeure. So what is force majeure? Easy answer for architects using PAM form. There's a ready answer which can be found in item AD under Article 7, which says force majeure means any circumstance beyond the control of the contractor caused by terrorist acts, governmental or regulatory action, epidemics, and natural disasters. Now, it must be remembered, force majeure is not universal. Your contract has to have specific provisions within it in order for it to be applied. So be very thankful the wise architects who drafted the PAM form actually put it in. Okay, so if there are circumstances beyond the control of the contractor caused by terrorist acts, governmental or regulatory actions, epidemics, or natural disasters, there is the opportunity and provision to declare force majeure. All right. Okay, but does the COVID-19...
we have about like 5 more minutes for you to finish up your slots to give way to Loo after this.
Oh, okay, then I'm running very far behind. All right. Okay, does the COVID-19 pandemic and the MCO qualify as force majeure? Well,
no, sorry. Joseph, I think you still have time. Husam, it's only 9:25 now. Joseph's site is supposed to finish probably in another 10-20 minutes. You still have time because 10 o'clock is only the Q&A session, right?
Husam, you don't like my voice, you just say so lah. Okay, no, so okay, if you look, COVID-19 pandemic is an epidemic, and a pandemic is an epidemic on a global scale, and the MCOs which have been put in place, they are all obviously governmental or regulatory action. So very easy, yes, COVID-19 pandemic and all the MCOs that came into place qualify as force majeure. Okay, so how does the PAM form help me? All right, so if the COVID-19 pandemic is amongst us, the MCOs have been imposed, can a contractor claim for an extension of time based on force majeure? Well, force majeure is listed as a relevant event. You're empowered to grant extensions of time based on the relevant event. So yes, contractor is entitled to claim for extension of time. So all of this, I think by April, all of you knew all this. So why are we wasting time on this? Okay, give me a little minute and I'll tell you why. I'll try and tell you why. Okay, some more questions. So if the COVID-19 pandemic, the MCOs are force majeure is relevant event, shouldn't EOT be automatic? Then make life easier for architects. Well, even if there are valid grounds for EOT to be granted, architects are not empowered to grant EOT without the contractor first having applied. Okay, and it has to be an application done in accordance to the procedure which we've talked about earlier. There are no provisions in this contract for the automatic granting of EOT. There are good reasons. As architect, if I'm going to say I can grant EOT automatically, it lends itself to abuse. By having a process, by having a contractor try and justify his claim, there is a process of check and balance, okay? And the other thing it must be remembered, just because a relevant event has occurred, it doesn't necessarily mean that the contractor shall be delayed. Best example I can think of, forget about COVID. It rained so heavily, exceptionally inclement weather. Contractor comes and gives you the weather records to show that on that day, the rain exceeded the average rainfall for the past 5 years, or even 10 years. And you get it and you say, okay, very good. But you were doing interior fit out. What has inclement weather got to do with the interior fit out? Okay, so just because a relevant event has occurred, it doesn't necessarily follow that the contractor is delayed. So my contention, when a contractor submits particulars of the cause of the delay, they must actually show how the relevant event event has affected the progress. Okay? And then it is using their substantiation or their documentation that you then assess and verify. Now, with the first MCO, is easy. They tell government, Prime Minister comes on TV, he tells you, stay at home, don't do anything. You can't go to work. That one is simple. If you can't go to work, you can't do anything, nothing gets done, and works come to a halt. All right, so that is simple. Okay. Okay, this is a question which I put, arising from the NCO, should architects only accept or consider claims for EOT based on force majeure? Now, just as the contract doesn't stop a contractor from submitting multiple claims, I've already mentioned he can claim for whatever he wants, okay? You as an architect are not empowered to go and say, no, you can only claim for force majeure. No, you can only claim for this. No, you can only claim for that. Whatever claim a contractor submits, you are obliged to assess. If the claim is not bona fide, not deserving of EOT, you don't give. All right. So I will get back to this issue about force majeure in a while, actually, but enough divergence, we go back to the main topic. So apart from EOT, what else does PAM Form do for me? Okay, simple. Now, almost always associated with EOT, delay. All right. There's also the sometimes problematic issue of loss and expense caused by matters affecting the regular progress of the works, for which a contractor under the contract is entitled to claim. Now, to give direction to the architects, PAM Form again lists out all the matters for which a contractor may submit a claim for loss and expense, clause 24.3. Now, should the contractor claim for loss and expense due to the COVID pandemic? He says it's my regular progress of works has been disrupted by the COVID pandemic. I want to claim for loss and expense. But if you go through that list and you can't find that matter within that list, as an architect, you're not empowered to approve the claim. Okay. Now, rather than spout terms out which cannot be found in the PAM form, my opinion is that if you receive such a claim, ask the contractor under which clause and under which subclause he intends making his claim. Now, again, now in the chat groups, when people say force majeure on the etc., everyone says neutral event, neutral event. You smart people, find me the term neutral event in the contract. Okay, when you want to reply to a contractor, are you taking terms arbitrarily? Are you plucking terms out of the air? Now, you and I know what a neutral event is, but if you have to justify your stand, my opinion is it's always easier to justify it based on what is written in the contract. Okay? And I can tell you, neutral event is not written in the contract. Okay, anything else? So you've received the claim for EOT, all for loss and expense, all in accordance with the terms of conditions of the PAM form. You've processed the claims, all in accordance with terms and conditions of the PAM form. You will hear me repeating this repeatedly, all right? And you grant EOT, or you actually approve a claim for loss and expense, all, again, all in accordance with the conditions, terms and conditions of the PAM form. But you still find the contractor saying, stupid architect, you don't know how to calculate, I disagree with you. You have a dispute. Now, apart from having provisions to review EOT after CPC, and please note that this is discretionary, okay? Architects are always entitled to review any EOT they previously issued after CPC within a specific time frame. But if you choose not to as an architect, there's nothing to stop you. So apart from this process of being able to review, PAM form also has mechanisms for dispute resolution. Now, there are 3 dispute resolution mechanisms in PAM 2006, and there are 4 in 2018. Now, I've written down here that actually there are only 2 principal methods which I think of are relevant for the COVID-19 pandemic. I have since had second thoughts on it. Actually, in my opinion, for PAM 2018, there are actually 3 principal methods. There's mediation, there's arbitration, and under PAM 2018, there's also now expert determination. Originally, I thought You need an expert to tell you whether there's a delay because of the MCO, man. But whatever, there is that provision for expert determination. Okay. So you get into a fight with the contractor, or the employer gets into a fight with the contractor over the EOT or over any claims of loss and expense. There is a procedure, there's a process to resolve it without having to take out knives and guns and meeting people in dark alleys. Right. Okay, short recap. So we've established PAM form allows for extension of time, set new completion date, keep time from being set at large. It gives us relevant events, so we don't have to think so hard as to whether a claim for an EOT is justified or not. All right. And in this case, we're very lucky. The relevant events seem to cater for COVID-19, the pandemic, and the MCOs. Okay. It allows the contractor to claim for loss and expense, which for the MCO and for the pandemic may not be relevant. It gives us clear procedures for the application and assessment. And don't forget, because once you issue EOT, a lot of the other clauses also tell you, please also arrange for the extension for insurances and things like performance bonds. This is all in the contract, okay? And finally, if there is a dispute, it gives us a procedure of resolving the dispute. Okay, that was the good news. Now for the not so good news. So what can't the PAM form do for me? It can't teach architects and contractors how to submit claims, assess claims. You've got to work it out for yourself. I still remember the first job I had using PAM 2006. Contractor got delayed because the piles which were not done by him were in the wrong position and the revision in the pile cap. So he said, okay, you're delayed. Yeah. Are you going to submit claim for extension of time? Yeah. Are you given notice? Huh? What's that? And you have to tell them, and you actually end up having to tutor the contractor. This is the process, okay? It doesn't tell the contractor which relevant event they have to refer to or they have to use to submit. And it doesn't tell you as an architect whether the relevant event he submits for is actually relevant. We've already gone through this. Inclement weather, you work inside. Don't waste my time, okay? It also doesn't tell architects how to assess. Because of the SOPs in place, do you give 1 week extra, 2 week extra, 2 years extra? It doesn't tell you that. You've got to sort that out yourself. Okay. And this is the one I have to spend a little bit of time on. It doesn't tell architects what constitutes the end of the cause of delay, which is in clause 23.1b. Because at the end of the cause of the delay, the contractor has 28 days to submit his full details. So what is the end of the cause of the delay? If I'm building a bungalow, I'm the architect for a bungalow, my RC frame has reached to the second floor, top floor. The employer says, hey, Mr. Architect, I want a veranda. Please put a veranda outside. So you issue out, you prepare drawings, you issue out the AI. The contractor takes it, okay. Yeah, Mr. Architect, I'm going to be delayed. I give you notice now. All right. So is the end of the cause of the delay the additional work, extra veranda, or is it the architect's instructing the additional work? Different views. I take it as being the instruction that instructs the additional work. Why? I'll tell you, if you look at the COVID-19 pandemic and the MCOs, I went through all those definitions, epidemic, pandemic, and so on, MCOs. Why? All right. What is the end of the cause of delay? If your delay, you are telling me, is the pandemic, pandemic isn't over yet. It's still there. So are you as a contractor going to tell me you cannot submit full details because by end of the cause of delay has not finished? Or is the cause of the delay the announcement of the movement control order and the SOPs? So Prime Minister or the Defense Minister in the newspaper come up and tell you what the SOP is and they publish it on the website, all right? Is that the cause of delay? As an architect, I will say that is. So the end of the cause of the delay is that when he finishes giving his speech or when they press upload and the notice on the SOPs go up onto the website. That for me is the end of the cause of delay. And I think that's fair. Once you can establish the SOP, a contractor can plan. He can tell you how long he will be delayed for. Obviously, it's not as simple as it sounds, because first we have MCO, one set of SOPs, no work. Then you have CMCO, another set of SOPs. For me, separate claim, because the delay is different, all right? But this is a personal opinion. There will be people who go around and say, the end of the cause of the delay is when the government tells me there's no more pandemic. If you are working as an architect on jobs like that, good luck to you, all right? Now, the other thing it can't tell you, it can't tell you how to convince the contractual parties that your decisions are fair and in accordance to the terms and conditions of the contract. Okay, I don't know how to do that even to this day. It can't tell you whether to advise the contractual parties to settle their disputes, if there are any, by either using arbitration, mediation, or getting expert in for expert determination, or hiring expensive lawyers and spending the next 3, 4, 5 years in court, or telling the contractor and the employer, hey, let's go for a cup of tea in the mamak store and let's see if we can resolve this. All right? It doesn't tell you how to do it. It can't, also the other important one for architects, it can't tell you how to keep the contractual parties reasonably happy so that they don't end up suing you. Then the other one, more relevant now, PAM Form can't tell you how to incorporate SOPs for working and testing of the workers during the pandemic. You have to sort that out yourself with the contractor. It doesn't tell you how to assign liability in the event that your site becomes a COVID cluster. Now, I put this in because personally, I think this is PAM Form. Liability shouldn't have never been an issue, but I have heard from some architects that there's 1 or 2 developers in town telling the contractor, if your worker kena, I'm holding you responsible. Now, how they're going to try and do that in a court of law, I don't know, but that's their problem. Okay. Next point, very, very, very important point, and this architect Loo is going to talk about this. It doesn't empower you to unilaterally change any of the terms and conditions of the contract. Okay. If something you find in the contract doesn't work for you, I don't want to process the claim for the pandemic and for the EOT. I will change the conditions of the contract. So I'll say, architect hereby empowered to grant whatever EOT I want. You're not empowered to do that. All right. It also doesn't tell you what is fair, equitable, and practical. And sometimes being fair is not necessarily the same as being practical. Okay. So the PAM form is a useful tool, but it's not a universal one. Okay, we've seen that it has its limitations. All right, it can't solve any of your all of your problems on the site, let alone those which arise during the pandemic. So my best advice is that you have to be knowledgeable about the PAM form in order not only to use it appropriately and to the best of your abilities, but to also understand what you can't do with it. What are its inherent limitations? Okay. Now, PAM as a learned institute, I have to say that, even sometimes I think I don't believe it, but it is a learned institute. PAM is aware of these limitations. That is why it came out and issued a practice note, serial number 3-2020. It's entitled Contract Administration in Relation to COVID-19 Act 2020. This was issued in December 2020. Hey, but from the title, it says it relates to the COVID Act. Even though it's supposed to relate to the COVID Act, this practice note actually contains quite a bit of valuable advice for running a contract. Now, rather than hide behind the terms and conditions of the contract, it advises architects or contract administrators and the other consultants to take a practical approach to mitigate disputes for the benefit of the contractual parties. Okay. When everyone is trying to survive through the COVID pandemic, you can't go to work, client want to pay you. The client, on the other hand, can't collect money from the purchasers. The contractor cannot work. He also cannot get his interim certificates issued or honored. So when you are trying to survive, everyone is trying to survive. Do we really need to pick fights with those whom we are dependent upon? Okay. Now, it also advises architects to encourage contractual parties to discuss issues on ongoing projects with the objective of preserving common interests the capitalizing is by me, as opposed to insisting on strict contractual rights. Now, you must remember that if the contractor doesn't survive, he all of a sudden gets a winding up order and he goes bankrupt. Employers and architects, we will end up incurring extra costs because we're going to find replacement contractors, and we'll also probably lose money. Okay, and similarly, if the employers don't survive, what hope do you think you're going to get? How are you going to get paid? Okay. So practical suggestions in this practice note include the following: exercising leniency when processing and assessing claims for EOT. Why force a contractor to substantiate the delay under the first MCO when even the Prime Minister on TV tells everyone to do don't go to work? All right. Now, rather than strictly following the contractual provisions for loss and expense, having the employer bear some of the additional costs arising from the delays, such as for the extension of the performance bond and CR insurance policies. Okay. Now, although these are, in my opinion, very practical suggestions, it must be remembered that they require agreement by the contractual parties. Right? So getting the contractual parties to agree as a contract administrator, this is, in my opinion, one of the items that distinguishes a good contract administrator from one which is maybe not so good. Okay, so if you are a ace contract administrator, you can get the contractual parties to see the practical benefits of tweaking, adjusting some of the terms. You should also be able to get them to sit down, review the situation, the SOPs, the testing, the reduced workforce, etc., maybe the delays in cash flow. You should be able to get them to sit down, review the situation, what are the resources available, what are the restrictions in force, and maybe agree on a new completion date and the division of costs, if any, without having to go through the whole process of applying for EOT. Now, this will never be in the PAM form. This will never be officially told in any official channel. But generally, I find sometimes it may be better just to sit down, say, okay, contractor, you're delayed. How long do you need? Employer, he says he needs that. Is that acceptable? Why don't we agree on this and move on, and you can concentrate on actually trying to finish the job rather than worry about submitting a claim for extension of time to me. Okay, I think it means less work, and it for not only the contract administrator but also for the contractual parties. I cannot advocate this for all jobs, but I, in my opinion, believe that this is a practical approach for a lot of the jobs. Okay, so, okay, what about the COVID Act? All right, this is where Mr. Loo comes in, all right? Thank you.
So, thank you very much, Joseph. That has been very insightful. We do have one question relating to contract, but I'd rather push it back to the Q&A so that we can have more live questions.
Okay.
And yep, so to continue with the COVID Act, and its relations to the contract, then I now invite Architect Loo Chee Keong to present the.
You want your own screen, Loo, or you want me to use? You want to use my screen?
Sorry, I can go on my screen.
Okay.
Just stop sharing there. I will share my screen. All right.
So,
hey, thanks a lot, Husam.
Yep. No problem.
Thank you very much, Husam. Before I continue with the excellent paper that actually Joseph prepared, I don't know why I'm in here because he prepared the whole paper. I'm just coming in as a backup to help him finish up with the final part.
You're better looking than me, Loo.
When he was doing the paper, I mean, we had a series of discussions. So we were talking about how perhaps a little bit about the COVID Act ought to be presented. Like it or not, the PAM Form deals with the administrative procedures within our building contract. But somehow, whatever that is happening in the COVID Act is going to affect all of us when we are administering this. Perhaps, how do I share screen now? Let me do this.
At the bottom.
Yep. Is it on now? Share screen?
Not yet.
Not yet. It's peculiar. I am trying to Okay. Let me just share screen. All right.
Okay.
Okay.
Okay, this is where we pause for a short while. So when we talk about the COVID Act, essentially there are two sections within the COVID Act which is more on our radar at the moment. The rest of the other sections is perhaps a little bit more remote. They are not really out of the picture, but if you look at in terms of what we are talking about today, let's concentrate on two particular sections of this COVID Act. Now, does this Act actually affect our PAM form? And does the Act actually help architects? The main area which affects us is actually defined in Section 2. Joseph talked about this briefly in a sense that the Section 2, what they are trying to do is trying to preempt a situation where you may be using a different construction contract and you did not have the foresight that our drafters did for the PAM form. Now, the PAM form by itself is very, very complete if you want to tackle the issues related to COVID-19. All the required clauses that you need to address all the delays and the disruptions is actually inbuilt in the PAM form. The only thing is, when you look at the PAM form as a tool, don't forget that there are many, many sections that you can refer to. Now, in event that you cannot come up to a conclusion and both parties the contract still argue, we have our inbuilt mediation clause. Now, as far as the COVID Act is concerned, let's continue with a brief recap on the COVID Act. It's basically the temporary measures for reducing the impact of coronavirus disease. We call it Act 829. So you basically have to swallow it and digest it and basically tick the parts that you want. Now, Part 2, Section 5, it comes into operation 18th March 2020 till 31st December 2020. How does that affect us? Now, this is actually an empowering date. And of course, if you look at the Act itself, it says for up to 2 years. What it means is that this particular Act allows the government to basically just add on, vary and whatnot within this period. Now, as far as our contract is concerned, when you talk about the 18th of March date, that is a trigger point. That is actually the lockdown date. And when you look at the various points, if you can recall, we are sitting down there in front of TVs, listening to the PM making announcements, what's going to happen today, it's going to affect you tomorrow, then you run helter-skelter. You can't do the things that you want to prepare. But all this, unfortunately, is very relevant to us as contract administrators. If you run through the dates, on the 16th of March, the PM announces MCO. It starts 18th of March to the 31st of March. And so forth, until a very important date. On the 3rd of May, the government announces CMCO. What this trigger point actually does is, you now have an option to work on site if you are not a sensitive project, all right? But it doesn't automatically mean that, you know, as contract administrators, we say, hey, that's a date. I'm only giving you the EOT up to that date. Because don't forget that these are all administrative relaxation. The contractor will still need to apply to MITI, right? He still have to get the approval. He still has to be able to actually mobilize his workers to go in. That, not alone, talking about what is all this SOP going to affect the way he does his work. Okay, you can talk about a scenario where, you know, yes, all my workers are back, but excuse me, I still have to do my physical distancing of 1 meter apart. How is my bricklayer going to do his work with 1 meter apart? You know, so all this would need to be taken into consideration, right? And now, recently, even as recent with the latest MCO, there is a restriction as to workers on site, and no contractor is supposed to add workers on site. Now, even if you wanted to mitigate and add workers on site, you can't do it, right? So as as a contract administrator, it is very, very important that you recognize the PAM form is a tool, but the PAM form is not enough for you to make decisions when you want to make, when you're doing assessments and whatnot. So as you are going along administrating the contract, please have the foresight to basically set up a system where you have enough information for you to make decisions. All right. Now, so part 2, section 5 says, you essentially, the effective date on the 29th of December, the actual order was gazetted. That is another trigger point, because this date is important to establish the end of a consideration on process. All right, I will come back to that later, because there is a issue about parties of the contract not being able to do the process. But if decisions have already been made within this period, the 18th of March period, up to the date that it was gazetted, there may be certain action that has already been taken. Those actions have a different position. All right, we'll explain later. So what is the act all about? If you look at part 2, the actual wording says inability of the party to perform. I think it's very important to recognize the word is a question of performance. Parties of the contract are not able to perform. So recognize that they cannot perform, so you intervene with an act. All right? And under item 1 of the schedule, construction work contract or construction consultancy contracts and any other contract related to the supply of construction materials, equipment, or workers in connection with the construction contract. Now, anything that has to do with construction, if you look at the wording, it talks about supply of construction materials as well. A main contractor may come to you. I may not be delayed, but my supplier is delayed. My lift coming in from Europe is not going to land anytime soon. All right? So then he will be issuing you extension of times claim, or in your mind, this will be in play. So to dangerously and to simplify, it means that for a construction contract using PAM form, an employer cannot claim LD for non-completion from a contractor, and essentially this thing is vice versa. It's basically one party of contract cannot lay a claim on another party and vice versa. So a contractor also cannot suspend his work. All right. So again, to illustrate the point that Joseph is trying to emphasize, does it mean that EOT is automatic? The PAM form does not allow you to do that. All right. You cannot assume that a contractor's intention is as such, because you must give him the opportunity to basically declare his intentions. If he wants to apply for EOT, let him do it. When you are a contract administrator, you cannot assume intentions of the parties of the contract. All right? You recognize their intentions at the beginning of the contract, knowing at the end of the day, everybody wants a profit out of the job. Everybody wants to do a good job. All right? Assuming that the contract is fair is very important. But when you are in the period where the contract is running, do not assume their intention. All right? But the contract is well worded in a sense that it gives a test of diligence on the part of the contractor, and it also defines the duties of the opposing party of contract, the employer, to basically make sure that your decisions are timely, make sure you pay, don't interfere. All right? Actually, the employer's duties are very limited compared to what the contractor's duties are. Because whenever you do contract administration, in my case, I find it always very easy to make sure that the test of diligence is recorded. So that at any one point in time, all right, when you have to do an assessment, you always have a point of reference. All right? Now, Does this mean EOT is automatically granted? The answer is no. All right. The Act allows for suspension, okay, on some obligations of the contractor party. It makes no specific mention on EOT and setting new completion dates. Those are still subject to application, you assessing the application, and you making a recommendation and eventually granting it. So, tucked into this part 2, section 10, back to what I was trying to illustrate. It tries to circumvent a disruption in performance of duties. But if for some reason, certain decisions have already been made, a real case, if let's say a contract ends on the 18th of March, all right? The completion date is on the 18th of, or rather on the 17th of March. Come the 18th of March, technically a CNC should have been issued, right? The contractor is still running in a period of delay. And a diligent architect may have, on the 17th, processed everything. You are definitely running in a period of delay, all right? And you issued out the CNC on the 18th, say on the 18th, all right? This Act recognizes that whatever you have issued out is valid, all right? But does it mean that the contractor now have no recourse? Don't forget that EOT and whatnot, he can still claim his EOT. You can have issued the CNC, he can still issue an EOT because it actually, at the end of the day, do not restrict the contractor for basically exercising his responsibilities or his options under the contract. All right? Now, that said and done, you recognize the period and you need to essentially assess every application that the contractor will or might give to you during this period. Now, it is undeniable that the Act does provide relief and clarity, but it doesn't, give you all the answers. So for us to do that, basically, the government says, look, as Joseph rightly pointed out, some contracts have no mediation clause, all right? We have a mediation clause in our PAM form, but there is a fundamental difference, all right? The process of mediation, under PAM form, you will basically go through the mediation rules, but under the COVID Act, they give you a process to say that the minister decides the mediation process. How the mediation process is supposed to take shape is not elaborated. So there is actually two options that you may want to do. A contractor or employer may decide, look, I love the PAM form and its mediation clauses so much, let's just follow that. But for other contracts, if you do not have a mediation clause, then now, okay, the government says your options is open. Now, I've actually referred some of the clauses within this COVID Act, like in all process of dispute resolution, alternative dispute resolutions. If you look at this particular Act, it does say the mediation results is actually final. It's final and binding, but actually it has no meaning. Everything for sake of natural justice is still subject to judicial review. So whatever the findings of the mediation is, you can still submit for, you apply for, review and whatnot in the courts. All right, but it does give an avenue at least for the disputing parties to come. Just shake hands. A third party comes in. He's an independent. Let's just see what his views are. If we can agree with the conclusion, let's just agree with the conclusion, right? Now, the government, when they set up this, they also set up a pusat mediasi COVID-19. This is to help, since they've already introduced mediation, they're actually setting this up in the hopes that when there is actually parties who are basically aggrieved and have no means to actually hire, big shot lawyers to take care of their problems. So they can still apply. I do not have details of this. I hope if Joseph had, perhaps he can share it later. But the link is actually here. Anybody who basically feels that you need their assistance in this can always contact this particular website. So again, back to the issue of force majeure. All right, not all contracts had the foresight that we had. We define force majeure rightly under the articles. We basically impose a recognition that there will be disruption due to the pandemic, and essentially the Act also established a period for the above disruption. I stress again, no claim, especially on EOT, is automatic. You cannot have the period of 18th of March up to the 31st of August as a bullet point. Can't use that. Neither can you use the 31st December date. But these are important dates to frame the restriction that the government has imposed. All right. How this imposition of restriction affect your contract is subject to how the contractor applies his EOT or whatever claims, and how this is actually set in the framework of that timing. Now, it does basically provide relief for having to perform contractual obligations within this period when such performance may not be practical, feasible, or delayed, and it provides a process. So you know, the avenues are there, but even without all this, the PAM form already has all these things in place. Okay, so to summarize it, actually the effect of the Act is actually quite negligible with the impact on our PAM form. Okay, all the provisions are there. Okay, we have already the provisions to resolve disputes. Which option is a better way of mediation? This is better argued based on the merit of the cases. Okay, now this particular item, okay, if does the Act complicate the running of contracts? Part 11 defines responsibility duties with regards to Housing Development Act. Of course, we can't detach our duties into it because, like it or not, the government already gave us a role to become the independent assessors when it comes to certifier with certain things. But what does the automatic granting of timing for to not impose LD, delay in charges and whatnot, defects liability period, how does this interplay in our contracts? Because actually there is no direct link from this Act giving you the ability to say, Mr. Contractor, because this is now extended, I'm sorry, your defects liability period is extended. All right, there is no direct connection when it comes to that. Your building contract under the HDA may be extended, all right, the defects liability, but there's no provision through the Act for the PAM form to give a direct extension, an immediate extension for the defects liability period as covered under PAM form. How I in my practice, how we do it is essentially, don't forget that you have a duty to submit to the main contractor a schedule of defects. That is your duty as an agent of the employer to give information for the contractor to act. Now, can you perform your duty? If you cannot perform your duty, the PAM form does recognize, even through the recommendation by the authors of the PAM form, it does recognize that if there are circumstances that does not allow a party to give this information to the main contractor, then parties of the contract may agree on a third, a separate timeline. So it gives you an avenue, essentially, that you may not have to, insist on a date that the schedule of defects is given, all right? But what can happen is both parties, if they can recognize that certain performance cannot be done, they should be able to sit down rationally and essentially, at the end of the day, what does it mean? At the end of LD, what the contractor wants is just give me my last my final moiety. That's all they're interested in. All right. So it's a question of money being paid, the final money, but now being hampered by responsibilities that, look, certain units we recognize. You know, for example, housing projects. You may have a high-rise tower, 300 units, say 5% of it is foreign ownership, people who are outstation, can't get to their house to even check the defects, to even give you a final list. So let alone, how do you then, this list gets transferred to the developer for you to process and give to the main con? Can't perform, you know? So this is covered under the Act. Developer is covered, main contractor is not covered. So if the main contractor is not covered, as a contract administrator, you may consider using this as a reason to inform the main con that, look, I can't give you the list. So whether it is a automatic extension on the defects liability period, the PAM form is silent. But I have not seen at this moment in all the contracts that we are doing that a main contractor is not willing to sit down to essentially discuss about this issue, come up with a separate agreement. All right, the PAM form does not facilitate you to do that, but it doesn't mean that both parties of the contract cannot sit down and have a supplementary agreement. Okay, Mr. Contractor, out of 200 units, okay, let's do say 20 units are not, you know, I can't perform. So 180 units, let's just release 90% of the last moiety. The extra 10%, let's just keep it, agree on a different timeline, and then come and re-evaluate it at the timeline later. I feel that this is probably in the spirit of what the PN is asking us to have a look at, you know. Think about all these steps that you may be able to help yourself to dig yourself out of a hole. All right. So which comes to this. It does not tell you basically how to be fair, how to be equitable, but it does, you know, there's basically it's left to our discretion how you want to be fair about it. Now, Joseph was trying to pin me to a corner to say about intent and whether how to be fair and how to be justifiable. Now, in all my years of administrating the contract, I've always looked at a few things as far as when I'm assessing claims on time, when I'm assessing claims on basically cost and whatnot. You know, I give you a few scenarios. A contractor comes to you, Mr. Architect, I now have so many SOP, all my workers are foreign workers. Time and again, the government is telling me, test and retest and retest and retest, who's going to pay me? All right. So when you are put in this position, what do? You're probably scratching your head. I don't know. This one is a contractor's responsibility, or maybe 50-50, maybe since employers paying everything, maybe you should just pay. All right. So don't forget that your contract comes into fruition because it is a process. All right. When you invite the contractor to come on board, you go through a tender interview. You should, in this period, as what I try to do, is to pin him on intent and also try to put as much on paper as possible. When a contractor comes and tender a project, did you put a gun on his head and say, go and hire foreign architect labor? You did not, isn't it? If on site everybody is not a foreign laborer, is he then obliged to pay? He's not. Okay. So similarly, now with the most recent one talking about, look, but the issue will still be this, all right? Similarly, when it comes to the most recent one, the huge hoo-ha over housing of workers on site. Now, this is another thing that you have to be very careful, all right? When you look at your tender document, do you basically also dictate the design of the housing accommodation, or do you leave it to the main contractor to basically price it, take care of the responsibility of that particular section, and he handles the cost of it? I can't tell you what is the right answer, all right? Because I do not know in what structure and what form your tender and your contract eventually is. But all these things are very important. And don't forget, every contract by itself, like we said earlier, is very unique. I have got employers who basically add so many clauses in that the PAM form, it doesn't strengthen the PAM form. They try to strengthen their position, but sometimes this sort of thing will interfere with how you interpret the PAM form. So it's very important. All right. Now, the COVID Act, they do have their shortcomings, like it or not. But when you look at the PAM form, I think you have enough tools in there for you to do your work. So perhaps when we look at how everything runs, the government will still be reacting. Don't forget this thing. Everything is basically developing. Everything is in a fluid situation. Everybody is trying to make sure that they react correctly. So in conclusion, what can we say? At this point, it's still with us. We have to get used to working around it. Okay, if you are using the PAM form, some of the solutions definitely is in there. There are provisions to cater for all the disruption that you have. Now, the author of the PAM form, be it the 206 or the review under 218, this disruption has never been imagined. All right, you cannot imagine it, but I think there's enough for you to actually for you to do your job. Okay, the COVID Act is with us. You don't have to worry about it. It's whether it's beneficial, detrimental. All right, with your running as on your job, take that out of your mind. Okay, basically, I think the more pressing issue is not currently what you have on your contract. You should be thinking about how you're going to draft your next tender. All right, if you see that there is going to be something deficient about it, think about how you want to do your next tender and how you want to conduct your tender interview. All right, yeah, there's no ready solution, so just be a little bit practical. Perhaps listen to a little bit more talk and listen to Joseph because he knows a lot. Okay, and now this is very important. We are contract administrators. You can't make arbitrary decisions, you know. It's like a football game, you know. Both opposing parties decide to play football with one ball. You can't say, okay, here's now 2 balls, go and kick. You can't do that. You have the clauses inside with you. Inside, the architect's empowerment is all within there. Don't make a decision that is out of it. All right? It's just like why Joseph keeps on, and I also agree with him. You cannot give an automatic EOT. All right? Let the contractor decide. He wants to claim his EOT under which clause. All right? You cannot say, I think you deserve it, so I'm going to give it to you. Okay, force majeure. You can't tell him. He may not want to. All right? Okay? Now, second part of it, what did you add to your standard form? Very, very important. Okay? Third thing, now, fundamentals of contract administration and decision making. I've put in a few terms inside here. You need to understand the fundamental principles of the clauses so that you can assess the impact of the claims. Don't forget that the principle of fairness that everybody assumes the architect has to perform. The element of option and risk pricing, when a tenderer prices, he is making certain assumptions. And also the issue of, at the point of tendering, could I have foreseen something like COVID-19 is going to happen? All right? If you have managed to take that into consideration, and when you do your recommendation, and you somehow display your ability to do that, I don't think anybody will find you guilty of being an unreasonable architect in your assessment. Okay, and this scenario, like it or not, unprecedented. So basically, what we are supposed to be doing is to complete an incomplete agreement, just like how a court will basically take care of all claims in our assessment. So don't assume intentions, and you should be fine doing that as long as you have all your facts on the table. I think we have ran more than time, so I will like to put the thing back to Husam to moderate. Thanks a lot for your attention.
Thank you, Architect Loo. So there you have it, ladies and gentlemen. Presentation by our two distinguished architects, Architect Joseph Tan and also Architect Loo Chee Keong. We do have one raise of hand, and we also have one Q&A on from an anonymous attendee. So I'm probably going to read that one first. Can client disagree and prevent architect from issuing the EOT for the MCO period? The contractor has only applied for the period from 18 March 2020 to the day that they are able to start work. They are not claiming for work progress affected due to the SOP. But before you answer that, now we are not actually obliged to tell the contractor that they should claim for EOT, isn't it? So they should know that. And I noticed, like when all this COVID was happening in the beginning, most practices, they were very reserved or very reluctant to actually act on this, and especially they don't even want to hint to the contractor that the contractor should actually be filing a claim for EOT. So there's actually a scare because they are not, well, the architect don't want to be the point for the EOT, you know, because giving an AI or anything like that would actually be a trigger point for the EOT. So that is one. One is to get the EOT to be registered, to be submitted, and second is if the architect were to actually issue out an EOT, what happens if the client decides to not, wants the architect to retract or not issue out the EOT? So I'll open that up for both. Yep, Joseph, you want to answer?
Okay, no, because while Loo was talking, I was looking at the question. So actually, before the second question came in, I already answered lah. All right. Now, Architect Loo and myself, we both serve on the PAM Practice Bureau lah. So whenever we get queries like this, we all have a standard format. First off, reply depends on whether you're using the PAM form. If you're not using the PAM form, you're using your own form of contract. I don't know what is written in. But if you're using the PAM form, okay, first part of the question, all right, let me get the question. Can client disagree and prevent architect from issuing the EOT? Okay.
Joseph, he rephrased.
Yes, I know. I will get to that. I will get to the rephrasing because basically, it's actually the same thing. Architect Loo has already repeatedly emphasized, claiming for extension of time is not your business as an architect, it's the contractor's business. To answer Husam's question, a contractor should be monitoring his progress on site every day. If he knows he's going to be delayed, PAM form already tells him, hey, give notice. All right. And you as an architect cannot say, no, I don't want to accept it. You are not empowered to do so. And similarly, in my opinion, if you are a prudent architect, you have site meetings for what? Sit down so you can drink the free bottled water they give you on the table? No, you're going to monitor progress. If the contractor is going to tell you, Mr. Architect, I'm delayed, or even after in CMCO, you manage to have a virtual site meeting, first thing you're going to say, Mr. Contractor, are you delayed? Yes. By how long? Have you given notice? That would be the first thing I will ask. Okay? So you do have a job and you can't stop the contractor, but I would say that you also have to advise the contractor, if you're going to be delayed, make life easy for everyone. Give notice and submit your EOT, because if you don't, I am obliged at the completion date to issue the CNC. No questions asked. Going back to the question, simple. All right. Now, under PAM 2006, so if you're using PAM form and 2018, EOT is granted through a certificate of extension of time, unlike in 1998. Now, then if you look at clause 26.1, now a contractor may determine his own employment if an employer defaults, in other words, commits a breach in one of the following ways. And one of the following ways is if the employer interferes with or obstructs the issue of any certificate by the architect. So there's never right or wrong answer. If the client tells you as architect, don't you dare issue the certificate for EOT. Otherwise, I'm going to send my guys around, they're going to beat you up. And the contractor doesn't know about this. You say, yes, okay, I won't issue. Fine. But if the contractor finds out, first off, he's going to report you to Lembaga because you are in breach of your code of conduct. And then similarly, he's going to determine his own employment because the employer has interfered with the issuance of a certificate. Answer your question? Now, it doesn't matter whether it's MCO or non-MCO or whether it's for SO, not claiming for SOP, etc. All that is irrelevant. That is for you to assess. Question is, can a client interfere and tell you don't issue? No. Easy answer. Okay. Lou, you want to add anything?
It was interesting. One interesting point is because
perhaps I
sorry.
Yeah, Husam, go ahead.
Yeah, because Joseph actually brought up clause 26. So this is also in the view that the PAM form, if I may use Anthony's language, if the PAM form is not molested, means that it's not the parties don't arbitrarily just cross out clauses and the forms are being used to its full form. Yeah. So Lou, you want to say something?
Yeah. No, I mean, reality is this lah. Those of us who have who are fortunate enough to basically get the appointments under quite a lot of public subsidiaries of public listed companies out there have a very strange understanding that we need their approval to actually issue our EOT. If you look at a lot of appointments, they say, if you don't get my approval as the employer and you issue an EOT, you basically are not doing your duty. I'm sorry, if you want to use the PAM form, I hope all the other architects who are employed under some circumstances actually advise the employer. You have to avoid a situation of interference because that is not to your benefit. It's never to your benefit. All right. And like Joseph mentioned, he can come to you and basically put a gun on your head and say, don't issue. It's for you to take action on. But what my practice does is, and I don't know whether others should actually adopt a similar approach. Contractor applies. He writes an application to you. He CC copies to everybody, right? Now, what I normally do is I write to the employer. The contractor has applied. Do you have any information that's going to help me in this assessment? I give him fair chance to say something first before I assess. Then I assess. All right. When I assess, I will tell you in no circumstances, these are the facts of the case. I'm using all this information. This is my assessment. Give them a chance first. All right. Then make a decision. In any case, as a reasonable architect, you do what you need to do. He can't stop you. He can't, after you've issued the EOT and say, look, I don't recognize it. He can't do that. Right?
Great. So
can I just add? Okay. Now the EOT, your certificate of EOT, there's actually no obligation for you to do the breakdown, okay, to justify it. But it is my opinion that if you're a prudent architect, you don't want to have a lot of problems. Do the breakdown and justify it. Then people have got nothing more to say. They will always argue. They will always argue. But at least you know where you're coming from. Okay. Husam, got any questions to ask or not?
I think Husam asked one about the apprehension of actually issuing the AI, right, Husam?
Yeah, it's because it's always the employer usually disagree.
Yeah.
And they'll make a lot of comments, and they say no, not their problem. My money, not your money, this kind of thing. But I think it's I think on the to the very fundamental, I think a lot of us understand the requirements, what needs to be done, and what is the best practice to for us to actually employ. But when it comes to work on ground, we are always held up by this people-to-people relationship. So that really requires us to step up and really show our position as the contract administrator. And one thing that was mentioned just now is that finding the middle ground between between all the parties means that for example, the loss and expenses now, who's going to pay for it and all that. It's also interesting to see how we as architects, we maneuver and administer the contract and control how the project is going. And to have both parties mutually agreeing on something that both will be on the losing end. Yep. So I'm getting the notice from the from this PAM training. I'm not sure who this person is on wrapping up. So I do hope that PAM training would reveal his or her identity to me, so it's easier to communicate. But rest assured, I think a lot of us has got a lot of information from this morning. If you are interested to read more on the PAM practice note, go to the PAM website, click on the PAM professional practice section, and then there will be a practice notes. And the COVID-19 is listed as practice note number 3. And you can go on various websites to also download the COVID Act and do have a read on both of that. I think it's been about a year now, 349 days. There have been a lot of discussion, and we all need to basically compare our notes, share, and find the best solution and best practices. So I'm giving Joseph and Loo opportunity to give their last words before we end the session. Probably Joseph first.
Okay, now Husam was very clever. He told you there's no soft copy available for PAM form, so don't go and find the cetak rompak copy, please. Okay, and then I just want to end off. Look, there's no answers, and you cannot escape from contractors putting you on the spot. Husam was talking about AIs. What happens if the contractor writes to you and say, with the MCO, Mr. Architect, in accordance with clause 4.1 of the PAM form, I'm asking you for instructions as to whether to confirm whether I should comply with the SOPs and stop work. What are you going to do? Okay, are you going to keep quiet? All right. So you all have to be a bit smart. You all have to think what is best for the project. And worst come to worst, sit down now. You know, not all contractors are crooks. Not all employers are out to cheat you, and not all architects are incompetent. That's what everyone thinks, but really it's not. Okay, Loo.
Yeah, I only got one thing to say. Very well presented paper, Joseph. Thank you very much for letting me share this platform with you. Cheers.
Okay, thank you very much, everybody. From the PAM Practice Committee, we are very happy to have all of you here with us this morning. We have another 3 more sessions. Please make sure that you have the full day and the full day of PAM CPD. And hope to see you guys around. Thank you very much from me, Husam, Practice Committee Co-Chair, signing off. Have a good day, everybody. Bye-bye.
Thank you,
Thanks.
Bye. Bye.